People v. Seignious.
Good afternoon, and may it please the Court, Franklin Gunther for the people, and if I could reserve 3 minutes for rebuttal, please.
Yes.
Your Honors, this case is about whether the defendant received fair notice at trial of the lesser-included offense of second-degree burglary. Now, by charging him with the greater count of sexually motivated second-degree burglary, the people necessarily placed defendant on notice that he would have to defend against all of the elements of second-degree burglary, including his intent to commit a crime upon his unlawful entry. Thus, as we argue in our briefs, the prosecution cannot and did not here disavow the possibility that they would later seek the lesser-included offense merely by urging the jury to consider that distinct additional element of substantial sexual motivation. But that's precisely what the appellate division held here, that by focusing on the distinct element of sexual motivation, the people essentially deprived defendant of notice that he would have to defend against a burglary. And that rule makes it essentially impossible for the people to request a lesser-included offense in situations like this one where you have a sexually motivated...
Counsel, what's the difference between motivation for purposes of, that enhancement, sexually motivated crime, and intent, as that term is generally understood in something like burglary?
Well, in the burglary context, the intent element is...
Is there a special intent for burglary that's different than intent for, say, some other crime?
Only in the sense that, with respect to burglary, the people don't have to necessarily specify an intent to commit a specific crime. They can do that in the charging instrument. That's not what happened here.
So burglary incorporates an element of intent to commit a crime once the burgling is done.
Yes, and then the motivation aspect is what is the purpose for the unlawful entry, that additional crime of the burglary.
Got it. So now distinguish motivation and intent for me, just so I'm clear on how to read this record.
Motivation is your purpose for committing the unlawful entry. The intent element is, do you intend to commit some crime once you have committed that burglary?
Could those two things, I'm sorry, one question. Could those two things be the same? Your purpose for wanting to commit the unlawful entry and your intent for committing the burglary? Is there any scenario where those two things could be the same, or are those by necessity different?
There are situations where that could be the same, but as the appellate division held here, under the statute, we actually established that there was a reasonable view that although defendant's intent may have been to commit one thing, it was not necessarily, his purpose was not necessarily substantially motivated by his sexual urges.
Okay. Can I ask it a different way? If the burglary itself has to be done for the primary purpose of sexual gratification, right, if you're going to make the extra element. And one way you can show that is you enter the dwelling with the intent to commit, let's say, a sexual assault. It's a pretty obvious example. But could it also be that you commit the burglary itself for sexual gratification? That you enter the dwelling, and that's, you go into somebody's bedroom, and that's the sexual motivation. Not the crime, maybe you tend to steal something there, right? But
no, I think that's right. I think you could be motivated to, you could intend to, say, steal someone's clothing when you commit the unlawful entry, and the purpose of that act or the purpose of entering the person's apartment could be sexually motivated.
That wasn't the question.
yeah, that's a little bit different. I get that. I mean, you can use a bunch of different crimes to larceny, right? I mean, the item you steal may give you that extra motivation, right? But what if just entering the dwelling itself of a woman, right, for this person, and going in the bedroom, that is the primary motivation, which is sexual gratification, but while they are stealing credit cards or whatever?
Yes, I think so. I mean, I think that is an example of a sexually motivated burglary with intent to commit perhaps a non-sexual crime. And I think that's what the evidence showed here, is that although we argued to the jury, I don't think it would have made sense for the people.
You have to have formulated the intent in this particular hypothetical for, I think you said credit cards, before the entry or as you're entering?
Well, I think that's what happened here. I mean, I think...
No, I'm saying in the hypothetical.
In the hypothetical of...
Would you have to enter the dwelling thinking, I'm going to steal credit cards, but the sexual gratification you get is from just being in that room?
I think in this hypothetical, yes, we would have to show that you intended... Well, you could show that it was after you entered the apartment and stole the credit cards, and you could show that that was evidence of his intent when he went in. I think that's right.
Counsel, it seems to me over here, thanks, and I'm interested in whether you agree that perhaps there are two ways in which the people could limit themselves. I understand you say you didn't, but one is to limit yourself to proving the sexual motivation which results in the greater charge. And the second, I think, is to limit yourself to specific crimes that the defendant intends to commit with respect to the burglary once inside the building. Whether that is, larceny in another example, or perhaps a sexual assault or some other crime in the building itself. Do you agree that both are possible?
Yes, I agree, and I think you're sort of speaking to the case law that my adversary thinks applies here. For example, in the Roberts case, the people, or in the Barnes case, the people specifically limited themselves to, we believe that the defendant has committed burglary with intent to commit a larceny. They were not then allowed to later argue to the jury, well, you can ignore the larceny part because we also have evidence that he was committing an assault inside. That's the kind of express limitation that we're asking this court to clarify. And that just didn't happen here because of, I think, the nature of the evidence and also the way we charged the offense in this case.
But that would be distinct from the motivation question, right?
In what sense? Maybe not.
What I mean is the question of whether you limited yourself to a specific crime or crimes that would be committed within the building is I think, a distinct way of limiting yourselves than saying we are only going to look to prove burglary with sexual motivation and not the lesser included of Burg 2, period.
That's correct. I mean, we could have argued to the jury, if you do not find that this is a sexually motivated burglary, you should acquit the defendant. Or we could have said, Your Honor, as the people did in Rothman, we charge the lesser included offense separately, and then we tell the court at the beginning of trial, actually, we're no longer seeking that charge. We are all in on the greater offense. And because the motivation and the intent elements are distinct, you cannot limit your theory of the lesser included offense merely by asking the jury to consider an additional and completely distinct element from the intent.
I think in Barnes, as I understand it, it wasn't that in the trial the people tried to have it both ways. It was that in the trial, the people argued to the jury one particular crime that they intended to commit, the defendant intended to commit. When this court reviewed that case, we held them to that crime. It was that you're not going to be able to come here and argue something different on a sufficiency.
Yeah, Barnes was a sufficiency case. I think Rothman is sort of the next step there, where you say, again, you're not allowed to, either in the charging documents or in some affirmative statement that you make to the jury, we intend to prove that he intended to commit X, and then later say, well, now that the evidence supports also that he intended to commit Y, you can now ignore X and simply go to Y.
So why isn't it a factual finding as to how the prosecution limited its case? The rest could be legal determinations about what that means, but why isn't that determination? If I look at this record, is it a factual finding to say you limited your theory?
I mean, we're not disputing any of the facts that what the prosecutor said in this case, the way that the case was presented. I think that the application of the statute and the case law to those facts are purely procedural legal questions that this court could answer.
No, so, all right, you're saying no, but I just want to be clear about it. So, yes, the facts, what statements were made, what was filed and said in those documents, all of that is the record, it is what it is. But the appellate division looking at all of that and saying, oh, what you've done here is limit your theory. Before we get to the consequences of that, you're saying that determination, that conclusion is a legal one, correct?
Yes.
Okay. What makes it legal as opposed to factual?
Because it's a matter of the way that the people present their case as a procedural question, whether charging document places the defendant on fair notice, whether the statements that they make after that point place the defendant on fair notice. These fair notice questions are procedural legal questions. And again, we're not disputing any of the facts on the record here. It's a question of whether those facts deprive the defendant of his constitutional fair notice
Well, I
rights.
see your point on the ultimate conclusion, but if a judge reads a document and says, okay, this is what this says, I'm reading it out, right? And then says, and the consequences of what the people filed is the following. Isn't that based on the law and just what is on the paper and what a court intuits from that is a fact finding?
No, because those facts are in the record, and the statements that are being made are what they are. It's a question of, does that rise to a legal level as a matter of law, as the defense at one point believed them to be? Is this a legal question of deprivation of constitutional fair notice?
Well, no, that's what I'm saying. That's the consequences. The first part is, did you actually limit your theory? The next step is, okay, what's the consequence of limiting your theory? You limited your theory in this way. Now what's the legal consequences of having done that? I guess that's my question. But it seems your answer is no. The decision to, the judicial decision or conclusion that you limited your theory in this way is a legal determination.
Yes, because it's a matter of, again, fair notice and sort of, I mean, the way that we presented our case is based on the statements in the record and the charging documents, and all of those facts are set. It's a question of whether that rose to some legal challenge.
So is there a factual finding by the appellate division that the defendant was lulled into defending his case in a particular way? I mean, they refer to Rothman and then say that's exactly what happened here.
Well, I think, the appellate division looked at sort of this question of whether the defense was actually on notice. We don't think that this court needs to decide that. I think it's more of a question of, is it reasonable for the defendant to have notice that these are the charges that they might face?
I'm asking something a little different. Is there a way to read, or should we read the appellate division as making a factual finding of prejudice?
Well, I think the appellate division's finding that the defendant was lulled is, I think that they distinguish that from what the test has been up to that point. Now, what we're saying is that that's actually just not the test. The test is whether you...
So it doesn't matter if he was prejudiced?
I don't think this court has to decide whether he was prejudiced by this. I don't think those issues haven't been answered in these cases in the past. It's a question of whether the notice that was it reasonable for a defendant to know that, okay, I've been charged with this greater offense. I should expect that, and again, the indictment, but also the statute places me on notice that somewhere down the road I could be charged with a lesser included. And unless there are questions, I'll save her for rebuttal. Thank you.
Good afternoon, Your Honors. Jan Ho, again, for Appellant Jayquaine Seignious. I noticed that when my adversary was speaking to Your Honors, he seemed to make a concentrated effort to stay away from any comments made by the trial prosecutor below. And it's those comments in conjunction with the way they presented their case by charging and stuff that led the appellate division to conclude that they had in fact limited their theory of the case. There's nothing in the case law that says that they have to limit it by renouncing every other crime that's possible.
But did the bill of particulars say anything about limiting the burglary?
What we have here is from inception, from the indictment,
But
bill
did
of
the bill of
particulars,
particulars,
VDF.
right.
Mr. Seignious was only charged with burglary at Burg 2 as a sexually motivated offense, and then sex offenses. At no point was there ever a non-sex offense introduced into the case.
But what is a non-sex offense? Larceny.
Robbery.
Is larceny?
Robbery,
So
larceny.
larceny couldn't be the intent in the burglary crime if the people are going to show that.
Sure.
So what's a sex offense limitation here?
Well, because he was charged with burglary, which requires intent to commit a crime, and that it had to be in whole or substantial part for his sexual gratification.
Right.
So if you're limiting if the prosecutor is limiting themselves in the way this trial assistant did to a sexually motivated offense, defense counsel does not think, as they would in a typical burglary case, that they have to be ready to defend against any and all crimes.
Counsel,
So you're, thank you. So your argument about limitation, I take it, is only that the people limited themselves to proving a sexual motivation for the burglary, which yields the greater offense, and not that the people limited themselves to a specific crime that would be performed within the building.
Exactly, Your Honor.
Okay.
I mean, at no time did the prosecutor ever say, we intend to prove that he entered the building with the intent to commit a crime, and the purpose of that was for his sexual gratification.
but the
Wait, so now are you
prosecutor,
saying that the burglary, that you're saying that it's not generally a sexually motivated burglary, you're objecting to the fact that it was a burglary with intent to commit a sex crime therein? That's what the people limited themselves to,
That
the
is-
burglary? Okay, and did you object to that specifically below?
What counsel objected to below was that she was not put on notice that she was going to have to defend against burglary in the second degree without the
Generally.
sexual motivation.
Correct, but now
Yes.
you're saying that the issue is that they limited themselves to a burglary and the intent to commit the crime therein is a sex crime. But
Yeah.
that's what I'm asking. So is
Yes,
it
yes.
preserved? Is
I
your
mean, the
argument that you're
confu-
making today preserved?
Yeah, counsel objected that she was not on notice to the lesser included offense, so I don't see how that's not,
And is the-
not preserved.
I mean, again, what I'm getting at is that are you objecting to the burglary in the second degree in general? Or are you objecting to the people lulled you into some theory that it was a burglary with intent to commit a sex crime therein? Because the people don't have to give a crime, right? Under burglary 2, the people
Correct.
can just say, you commit a burglary with the intent to commit a crime therein, full
Correct.
stop. Or the people can say, we intend to charge you with a burglary in the second degree with intent to commit a crime therein, i.e. a crime according to Article 130 or sexual crime, correct?
Correct.
So those are two different avenues. So what are you objecting to here?
The people proceeded on the theory, they charged him with Burg 2 as a sexually motivated offense.
That's a different crime, though,
A different crime from what, Your Honor?
from regular burglary. We have
Sure.
burglary as a sexually motivated felony, that's one crime.
Right.
And then there's the underlying lesser included of burglary in the second degree, true?
Right, but when asked, when seeking to introduce Molyneux evidence, the district attorney, in response to the court, so you're saying this video proves his intent to commit a sex crime? The DA said yes.
Okay, and why isn't that, I think you're conflating the evidence for proof of sexual motivation, which was the Molyneux argument, with just the burglary below as the lesser included. Like, in other words, for example, I'm worried about what this means if we rule in your favor for a hate crime. Because let's say you have arson, and we charge arson as a hate crime if somebody sets fire to a house of worship, right? Would you be arguing that the arson is then limited in some way only to show it was committed because someone is anti-Semitic, because they charged the higher crime of arson as a hate crime? Do you
What I'd be
understand what I'm saying?
arguing is that if the district attorney, whatever the case, be it a hate crime or be it a sexually motivated offense, if the district attorney chooses not to either say, look, my theory is he did this for sexual motivation, but I don't rule out that he might not have. The district attorney here pursued one theory, made it clear that it was a sexually motivated offense.
when you
He
say-
was the one conflating.
So when you say made it clear here, are you talking about actions and arguments made in response to motions all the way through, up to and including trial, or just trial?
No, everything from the beginning up to and including trial, and it was only after the witnesses for this particular crime, because there was another one involved, had already testified and been cross-examined. For the first time, the district attorney said, now I want the lesser included, and defense counsel said, I had no notice of that. You have to look at what the district attorney was saying in response to all of these motions.
Okay, can we go back then to my example as the hate crime? Because if they charged it as arson as a hate crime, no other charge.
Right.
And they present evidence, and they're presenting evidence that this person engaged in other anti-religious, anti-Semitic acts as proof of the motivation of the hate crime, and then say, we want the lesser included of arson. Are you saying that it was limited then? Is that arson somehow limited and they don't get that charge?
No, Your Honor. I think the analogy fails because burglary is such an outlier. Burglary requires intent to commit a crime, and the people are not required, as they would be in your hypothetical, to prove a specific crime. The district attorney here did not have to say he entered with the intent to commit larceny or sex abuse or robbery or anything. He didn't have to. He had to say he intended to enter the private part of the dormitory with the intent to commit a crime. And whatever crime he intended to commit, he was doing it in whole or part for his sexual gratification. Unfortunately, here, the district attorney repeatedly referred to what he intended to prove as he entered with the intent to commit a sexually motivated offense.
So you're not suggesting that the prosecutor in all instances would be foreclosed for getting the lesser. It's just because of how this case was prosecuted that that limitation applies.
Exactly, Your Honor.
Here.
All he had to say was, open, I intend to prove he intended to commit a crime, and the purpose of that crime was for sexual gratification.
Yeah, but wouldn't a jury be free to reject the notion that he committed a crime for sexually motivated purposes, even on a sex crime? Couldn't a jury say, we don't think that he committed that sex crime when he entered the dormitory for his own sexual gratification? We think he did it to intimidate women, to assert his power and control. Is a jury free to do that?
I don't see why not, but the issue here is that because of burglary, and again, it's an outlier, Barnes says they don't have to tell anybody what crime he intended to commit, but if they do, they have to be held to it. So the question here, and what the appellate division found, was the way the prosecutor went through this case step by step. He never once separated out the crime from the sexual motivation.
So does the prosecutor then have to expressly state that they are preserving the opportunity to just argue a crime? Do they have to say something expressly under your rule, or how you would say we should resolve this case moving forward?
Moving forward, I think the rule is quite simple, and it flows directly from Barnes. If they limit their theory of the case, then they must be held to that theory. Again,
well, that's an easy one if they expressly say, I'm limiting my theory of the case to X, Y, and Z. So my question is, if that's not what they want to do they have to say expressly, I am not limiting my case?
Well, that's one way to do it. Another way is to simply describe this crime exactly as it's written. I intend to prove to the jury that he intended to commit a crime, and that crime was sexually motivated.
So if the prosecutor has said to his adversary or the court at some point during these proceedings, or even to the jury, the evidence is going to show here that this defendant entered with the intent to commit a sexual assault or possibly some other crime, we wouldn't be here today. Is that right?
Probably not, because The question here was whether the presentation of the case limited their theory.
And you're talking about exclusive reliance on on the intent to commit one crime, i.e. a sexual assault.
And that is what the prosecutor proceeded on the theory, and that's what the appellate division found.
So let me just ask you this next question. If the evidence shows something else, and I think the evidence must have shown something else because the jury did convict of burglary, but not a sexually motivated. So they must have found that he entered with intent to commit some other crime. And the prosecutor simply doesn't mention it. Is that not sufficient for the jury to make the finding that it did regarding intent? For example, if the jury watched security footage and they saw the defendant go into the dorm and assault a security guard when he got in there, would the jury be within its rights to infer that defendant entered the building with the intent to commit an assault and not a sexual assault, notwithstanding the fact that the attorney didn't argue it?
Well, I would disagree for two reasons. One, he entered the building. Where from there do we derive he entered with the intent?
I'll tell you where I derive it from. There was a hypothetical question before about someone breaking into a home for a sexually motivated purpose and then finding credit cards and taking the credit cards. And the answer that I thought I heard is that if you can show that they have the credit cards, that's legally sufficient evidence of intent to steal the credit cards. So and since the jury here did convict of burglary, they must have found an intent to commit some crime because they rejected the sexual theory, but they still convicted. And I'm wondering whether it really does key so much to what the advocate says as what the evidence is in the case.
But the point is that defense counsel was lulled into thinking she had to defend against burglary, too, as a sexually motivated offense. And then that's what he was charged with originally. But then throughout the course of the proceedings, the trial assistant repeatedly said, our theory is that, I believe what he said exactly was that the video was probative of his intent when he enters the dorm. He entered unlawfully with the intent to gratify his own sexual desire. When the court said, you don't have a witness to a sex crime, so this video is your only evidence that he entered to commit a sex crime, and he said yes. And he opened on that theory. He never said, no, he entered with the intent to commit a crime for purposes of sexual gratification.
But let's say if the prosecutor had said, in argument, they get the lesser included, and they say, we are going to show that he entered with the intent to commit a sexual assault. And the primary purpose of that assault was gratification. So that's this charge. But even if it's not for the primary purpose of gratification, it's a second-degree burglary because he intended to come in and commit that sexual assault. Would that have been okay?
When did they decide that even if it's not? When are they first making that announcement? Here, after all the evidence has been presented and defense counsel?
Yeah, what haven't you defended against in that case? Because they're saying he intended to go in, commit this sexual assault, and the primary purpose for committing that sexual assault was gratification. And when they get up in front of the jury, they say, that's all true, and that's our theory, and even if you don't find the extra element of gratification, you can convict under second-degree burglary because he intended to come into the dwelling and commit a sexual assault. Would that be okay?
Probably yes, because they're limiting their theory to sexual assault.
And what did they do here in arguing to the jury that's inconsistent with that?
Well, it's not a question of what they did in arguing to the jury once the court granted their request for the lesser included.
But in mine it was. It's the same hypothetical, except my hypothetical is the same facts here, except the argument to the jury is intended to commit a sexual assault, but for sexual gratification, but even if you don't find sexual gratification, you can find that's a burglary too.
Yeah, but the issue here is whether they deprive defense counsel of notice
Right.
that they at some point were going to be seeking
So is the answer
general
to my
burglary.
hypothetical that's a violation under your theory, or it's not a violation, my hypothetical?
Well, your hypothetical doesn't seem to be addressing when defense counsel is first finding out
Same
that she
facts here.
needs to defend against both.
Same facts here. Only difference is the argument of the prosecutor is sexually motivated because they tended to commit a sexual assault, and if you don't find the motivation, it's still Berg too.
And he's been saying that, he only says that
It's the
after the
same
evidence.
facts in this case, except for my argument.
Right, so at the charge conference is the first time he announces that if you don't believe in this, because that's what happened here. It wasn't until the charge conference that the district attorney said, wait a minute, if the jury doesn't find it was sexually motivated, they should be allowed to consider any regular burglary. It
But
wasn't,
the argument, everything that happened here happened exactly the way it did, except the prosecutor's argument to the jury is what I said.
I'm not 100% sure I'm understanding, but I'm going to say that that's probably improper. If defense counsel gets all the way to the charge conference with the belief that she is defending against a sexually motivated offense, the district attorney, sexual
Why
assault,
wouldn't that apply to any lesser included offense?
because, again, I can only go back
No,
to...
I know what your burglary argument is,
Right.
but why does burglary matter in that case? Because the prosecutor is locked into the crime, arguing the same crime, but you're just saying, but I was only defending with the extra element in it, right? It's not a surprise that you're arguing the burglary was intended to commit a sexual assault. You're just saying I was locked into the higher crime with the extra element. But that's always true of a greater offense that includes a lesser included. I was only defending against this because it was this crime with an intentional racial component. But I wasn't going to defend just the regular crime. I thought you had to prove this racial component. So when you got to the jury and you asked for this lesser included offense, why would I have to defend that? I was lulled.
I disagree, Your Honor. I think that the burglary, being the way it's written, cannot be analogized to other crimes, even hate crimes, because there the defendant is charged with a specific crime as a hate crime. He's not charged with intent to commit a crime for purpose of hate.
Locks into a specific crime, locks in. First degree sexual assault. That's what this defendant intended to commit in the building, from opening to closing, always saying that, and gets to the jury and says, even if you find no motivation, you still get Berg too. Why is that lulling the defense lawyer in?
But I'm not saying that. If you have a general case and if somebody's charged with murder, defense counsel is on notice that they might end up seeking manslaughter.
What is the unfair notice in my hypothetical? What didn't the defense lawyer have notice of to defend in my hypothetical?
I'm not saying that he, which one? The one you just said about?
No, the one where I've argued, the prosecutors argued from opening to closing that the defendant intended to enter the dwelling to commit a sexual assault, but it then asks for lesser included, and then says, if you find that the primary motivation wasn't sexual gratification, you can still commit under burglary too.
So you're saying that, yeah, maybe then defense counsel is on notice. If the prosecutor is specifically saying he intended to commit sexual assault, then they're limited to proving sexual assault, but I'm going to allege it was for the purpose of sexual gratification. I do believe that defense counsel would be on notice that she's going to have to defend against sexual assault.
And what specifically did the prosecutor argue here that was inconsistent with what you call a sex crime?
Well, I don't think he argued anything that was inconsistent, but under the people's theory, what he could have, because they only had to show intent to commit a crime, now the defense has to charge against everything.
Did they argue to the jury that it could be some other crime, a non-sex crime?
No, I don't believe that. Even after getting the lesser included, I believe the district attorney's summation really stuck to his theory that he entered with the intent to commit a sexually motivated offense.
But counsel, thank you. That's where I think I'm confused, and I think I'm following up on the exchange you had with Judge Singa. So I'm looking at page 37 and 44 of the record, which is the opening statement. And it looks to me like the prosecutor says, and I think this is part of what you're referring to, that the defendant entered the private area of the dorm to grab, grope, and harass the young women who live there. Now, I thought I heard you say in response to my question that you were not arguing that that passage, and there's a similar line at page 44, and you referred us to one at 537, that your complaint was not that the people limited themselves to specifically what crime would be committed within the building, that it would be harassment or forcible touching or whatever it was, but instead committed themselves to charging the burglary with the additional element of the sexual motivation. So do I have that right, that the objection is only the additional element of sexual motivation, that that's the lulling you're objecting to?
Correct.
Okay, and so what in that exchange suggests that the prosecution is foreclosing seeking the lesser charge of just the Berg 2?
Well, you're taking the opening statement in isolation, and as the
Well, the
found,
yeah.
it's not.
I just want to make sure I have the record pages. You have 537, you have 37 and 44. Is there anything else you would have us look at?
Well, certainly. You have to go back to pretrial, just a day or two before the trial started, when the people were seeking to introduce the video from Mr. Seignious' behavior outside. And in response to that, they announced that the touching of a sexual nature was extremely probative of his intent when he enters the dorm. They then asserted that he crossed the boundary, he committed a sexually motivated burglary. He entered unlawfully with the intent to gratify his own sexual desire, and that is the substance of the burglary charge. When the court said, oh, that video is your only evidence of a burglary, you don't have a witness to a sex crime, so his entry into the building was for the purpose of committing a sex crime, the district attorney said yes.
And I think that's at 537 of the appendix. So it's there, and the pages of the opening statement. Is there anything else you would direct our attention to? I'm not suggesting it's not sufficient. I just want to make sure I know
well, we
where all
also
of it
refer to the district attorney's representation in response to the motion to sever counts.
Okay, thank you.
So,
Thank
counsel,
you.
I'm
Oh,
sorry,
sorry.
just one last, I don't know that you can answer this. So let's say we agree with your adversary. How would that change trial counsel's strategy? Would they then always have to assume the possibility of the lesser included being charged to the jury?
Yes, I do believe that's actually what my adversary's position is, that by being charged with a greater crime, you should always assume that you're going to have to defend against the lesser included. And that probably is the rule, and I think in general that's true. I think defense counsels are aware of that. Again, burglary is something of an outlier because of that specific intent to commit a crime which need not be defined. And the question is, there's no question, if it is limited, then they have to be held to it.
No, I get that. I understand your point about the peculiarity, let's put it that way, of the burglary, the lesser included burglary, which is why I asked before, if I can come back to my other question. It seems to me, if we're not persuaded by his argument, we're more persuaded by what you are advocating, that the prosecutor would have to go about the business of making express, so not to fall into this quagmire, making express that they are not limiting their theory.
That's one way to do it.
They just say that. I just want to make clear I'm not limiting my theory.
Yeah.
And move on. Okay.
They could do it the other way too, and just refer to it as it's written. He intended to commit a crime for sexual gratification. There's many ways. It's not hard for them to not limit their case. And this, it's really...
If they say intended to commit a crime for purposes of sexual gratification, you say that preserves their position on the lesser included? Am I understanding you right?
Probably.
But isn't it not, it's hard not to limit your case when the top count is burglary as a sexually motivated felony, and I think you're saying all the evidence that's elicited on the top count, you are now using to confine on the lesser included. That's where my issue is.
But I think that if we look at it as respect to any crime, the district attorney is always going to put their focus on the top count. And nobody's here saying that by focusing on the top count, defense counsel isn't aware that they need to be defending against possible lesser included. So the question is, in pursuing the top count, did they go too far here?
Okay. Why, no, I'm sorry, one last, I forgot to ask about this before, when we going down this road about whether or not this is a factual determination. Are you in agreement that that decision, that indeed they limited their theory, you agree that that is not a factual determination? That was his argument.
No, I believe our position was that the appellate division's decision was a mixed question of law and fact, and that the appellate division did interpret comments by the district attorney to come to a conclusion, and then also look to the lower, also found that the defense attorney's representation that she had never been given notice of this, there was no prior colloquy about this, which the DA was saying had happened, that she was more credible and she was surprised by this. All of that resulted to a mixed question of law and fact, and this decision is not on the law alone.
Now you have your pending motion. Thank you.
Thank you.
Just a few brief points. Counsel said something about the mere focus on the greater offense would somehow be okay, but that's exactly what the appellate division said was not okay, that merely by arguing for the greater offense, we are now disavowing or renouncing the possibility of a lesser included offense. And the reason that that the focus is not enough is because the greater offense...
Well, I thought she was really arguing something else. I may have misheard her, so fair enough. I thought she wasn't just saying it's the focus, because of course you're trying to prove that particular crime, so of course you're going to focus on the crime in that sense. But it's that you're disavowing anything else. That's what the defense attorney understood from the statements, the actions, the conduct of the ADA, and that's kind of the difference. Not that she's arguing now to us that you couldn't have focused. Yes, you can focus, but somewhere along the way, the peculiarities of this record, right, led that trial counsel to believe that's all you're doing. You're not going to be doing anything else.
I think the case law suggests that you need much more than that. Okay. Barnes requires an express limitation. Rothman talks about, express disavowal by moving to dismiss the lesser included offense. Roberts, the case we cite in our brief, talks about how if you have a factual theory of the case at one instance and then it affirmatively disproves the evidence.
And what do you say with respect to defense's argument that all the way through the litigation of the case, the people did things that lulled the defense into thinking that you were, in fact, limiting the case with respect to the Molyneux motions and other things?
I mean, much of the pretrial litigation was really, like the severance motion, all that is a recitation of the facts. The grand jury testimony that they talk about in their brief, the prosecutor asks open-ended questions, as any prosecutor would at a grand jury presentation, designed to elicit facts about what happened at the crime. There's no limiting of our theory of the case at that point.
So your argument is this is no different than in any other case. You prove the greater, but just in case, always there's the possibility that the lesser would be requested.
Yes, as long as the theory of the lesser is consistent throughout, and there isn't some retraction of that notice at some point that is initially laid out in the indictment or or in other supporting documents, then yes, this is no different than any other lesser included offense because the motivation element attaches to the burglary. It does not attach to the intended crime that is part of the burglary.
Thank you.
Thank you.